Good morning. I'm Dan Levitt, BC Seniors Advocate. I'd like to acknowledge we are in the territory of the Algonquin peoples, the Songhees, and Esquimalt First Nations. Thank you for coming. I'm here today calling on government to address an issue that is a crisis in the making for BC seniors and their families. Recorded. One of the first issues brought to my attention when I began in this role was the alarming rise in the number of calls to our office regarding large rent increases being levied against many seniors living in retirement homes. Seniors are being told their rental units and the mandatory service package they must purchase as part of their tenancy, and that these are not covered by the Residential Tenancy Act, and the cost protections in the law don't apply to them. Upon review, I found the calls on this issue have more than doubled in the last year. My investigation found that some landlords are routinely failing to comply with the legislation, and there is sporadic and inconsistent enforcement of the act by government. Seniors have raised this issue with the province, but have been met with a bureaucracy that lacks the knowledge, skills, and resources to enforce the law on behalf of this growing population of vulnerable seniors. While there are landlords who comply with the law, there are many who do not. And the rate of the annual rent increases ranges from a modest rate of inflation to as much as 24% in 1 year. Seniors who can't pay are facing eviction. Government must act now to enforce tenancy protections for these vulnerable seniors. I want to take a moment to provide an overview of the senior living or retirement home sector. In the last 40 years, there has been an evolution in the retirement housing sector in British Columbia and across Canada. The number of what are called independent living and assisted living units in BC have increased. There are now more than 30,000 seniors renting units in independent living complexes in British Columbia. Independent living is essentially renting an apartment with basic meals and housing included with rent as part of the mandatory basic service package. And there are other a la carte services that can be arranged for additional fees. Often, these are seniors who have downsized and want fewer daily tasks such as housekeeping and cooking. In British Columbia, the vast majority of independent living units are private pay. As you can see from this slide, seniors in independent living have generally low care needs. Our report released today focuses on seniors in independent living. As I mentioned, these independent living units are primarily rentals. Under the Act, the vast majority of tenants in British Columbia have rights and protections. These include the protection against unreasonable rent increases and protection for any services they are required to pay for as a condition of their tenancy. The issue I'm raising today is government's lack of enforcement of the legislation protecting tenants from unlawful rent increases. For seniors in independent living, the rent and services form part of the rental agreement and are subject to the same rent increase protections. Because a senior must purchase the basic service package to rent an independent living unit, this package is part of the tenancy agreement, and both the rent and the service cost fall under the cost protections of the Act. Here is a story of a concerned caller to our office who raised a problem that she was being charged a 24% increase to her mother-in-law's monthly rate. I'll read it. Marjorie was concerned about a proposed 24% increase to her mother-in-law's monthly rate at an independent living residence. The monthly rate was $1,848, with a proposed increase to $2,300. When Marjorie questioned the landlord, they stated the Residential Tenancy Act didn't apply. She contacted the Residential Tenancy branch and was told they may not have jurisdiction over the situation. The landlord said she wasn't protected. The Residential Tenancy branch didn't know. Now I want to talk a bit about what we're hearing about the dispute resolution process. when a senior goes there for cost increases. Many seniors have told our office that the residential tenancy branch couldn't say whether or not the resident is covered under the legislation, and the senior must pay $100 to apply and go through a formal dispute resolution process before an arbitrator. Seniors tell us the dispute process is onerous and intimidating. It requires computer skills to complete online forms and applications. And some seniors were unable to complete the form on their own. Many seniors have told us they feel unprepared to represent themselves, while the landlord is represented by experienced legal counsel. The onus should not be on seniors to fight for rights they are already entitled to by law. We are urging government to ensure staff are adequately trained and equipped so vulnerable seniors in independent living are protected. It's worth noting that government doesn't track complaints specific to rent increases in independent living. Therefore, we believe the extent of the problem is underrepresented. It's almost impossible to track and monitor an issue when there is no data to review. Here we have a story from a senior who contacted our office about her total lack of practical options available when faced with a second rent increase in 1 year. Barbara received a second notice in 1 year saying her rent and services would be increasing by 14.3%. The landlord advised the Residential Tenancy Act did not apply when she raised the concerns. She refused to pay and was served a notice of eviction with 60 days to vacate. Barbara contacted the Residential Tenancy branch twice and was given conflicting information. She was too intimidated and frustrated to launch a dispute. She was forced to move from outside of her hometown to a new retirement home with more affordable rent. Before releasing my report today, I spoke to the Industry Association and several landlords to get their thoughts. Their general reaction was that any attempts to control cost would negatively impact their businesses. I understand this concern. However, it's important to note that landlords have been allowed to raise rents higher than the rate of inflation for 16 of the past 20 years. And landlords can apply to the government for increases higher than the allowable rate increase in cases of extenuating circumstances. Retirement homes are an important option for many seniors who don't want to or can't maintain a home on their own, but don't need the higher level of care in assisted living or long-term care. And government must ensure seniors living in retirement homes are protected. Diane and her husband, Hugh, contacted our office with concerns of an 11% increase to their service package at an independent living residence. The landlord told them their rent was going up by the annual allowable increase under the legislation, and the 11% increase applied to services they receive. Diane had escalated their concerns through the dispute resolution process, which ruled in favor of the landlord, despite having one agreement for rent and services. They ruled the hospitality services could be considered separate from rent and subject to an increase greater than the annual allowable rent increase. I met with Diane. She told me she felt very intimidated by the dispute resolution process. She found it onerous, time-consuming, and required computer skills, and felt unprepared because she had to represent herself. Meanwhile, the landlord had hired experienced legal counsel. After all this, Diane decided to opt out of some services to save money. But when she informed the landlord, the couple was threatened with eviction. Diane told me this was unfair because the arbitrator ruled services were considered separate from rent. Yet the landlord was now stating they can't live there without purchasing the services. Diane wants to pursue these concerns and go through another arbitrator, but is discouraged by her previous experience and is already under stress due to her husband's failing health challenges. Diane continues to refuse to pay for meal services and has received several eviction notices as a result. She's consulted a lawyer who wanted a substantial retainer to take on her case. Diane and Hugh have also recently received a notice of a 9% rate increase for services for the upcoming year. Diane worries that soon they'll be priced out of the residence they have called home. As you can see, this issue is very clear. Government must take action in several areas to ensure seniors in retirement homes are protected from unlawful rent increases. I'm urging the Ministry of Housing and the Ministry of Health to commit to fully implementing the following two recommendations. First, take immediate steps to ensure Residential Tenancy Branch consistently enforces the Residential Tenancy Act in recognizing seniors living rental units are covered by the Residential Tenancy Act, as are any services fees they pay that are a requirement to rent their unit. And secondly, review practices, capacity, and expertise of the Residential Tenancy Branch to address issues raised in this report regarding intimidation and vulnerability many seniors feel when trying to address legitimate residential tenancy issues with both the Residential Tenancy Branch and landlords. Our office will be monitoring the implementation of these recommendations. I look forward to receiving an update from the Ministry of Housing and the Ministry of Health within 6 months on the progress made to full implementation of these recommendations. Our aim is to ensure seniors in independent living are protected from unreasonable cost increases and afforded the same tenancy protections as all British Columbians. Private independent living is an important part of the continuum of seniors housing in British Columbia, and we want to make sure all parties understand the rules and that they're applied fairly. We want the tenant-landlord relationship for seniors in retirement homes to be balanced, and we want seniors to have the same rental protections as other British Columbians, and we want the rights of seniors upheld. I'd be happy to take your questions now.
Hi, thanks for taking my question. Has your office been able to calculate an average monthly fee that people are paying for in assisted living and maybe the average increase that you're finding people are facing, or I guess however many hundreds of dollars that it's potentially going up?
Well, thank you, Yvonne, for that question. So the average allowable rent increase has been the rate of inflation plus 2%. So we know this year, it's 3.5%. In other years, it's been much higher. So the independent living operators, they're ranging from a very modest rent in a few thousand to much higher than that. And in some cases, callers to our office who are concerned are experiencing rate increases that are double digits, and even in the high single digits, which are beyond the allowable rent increases.
And my follow-up question would be, what is your office able to do when people are coming forward to you with some of these really heartfelt cases where they maybe need to pursue legal action or they're facing potential homelessness as a result of not being able to pay anymore? What can your office actually do to help them?
We can do a couple of things. We can certainly refer them to nonprofit organizations, advocacy groups that would support seniors in those situations. We can give them some advice around what they can say to the landlord, and certainly we can advise them how to proceed through the Residential Tenancy Branch arbitration process. But as we're talking about these issues, it's very challenging for a senior when they're faced with a landlord who's increasing rent in a shelter that they're relying on that person where to live. So it's a very tenuous position that seniors find themselves in.
Next, we'll go to the phones. Rob Buffum from CTV.
Oh, hi. Thanks for taking my question. I hope you can hear me. I guess I just wanted to understand what the state of the law is, because you talked about the example of, I think the lady's name was Diane, who had her services increased by 11% or something above the 3.5%, and then wanted to sever that part of her contract. And the arbitrator agreed with the retirement home. Did the arbitrator apply the law incorrectly, and that's what you want to have addressed? Or are retirement homes allowed to offer a separate cost for things like meals Is that permitted?
So what's happening, the practice in the industry is that the rent portion is under the RTA, and they can only increase it by the allowable rent increases every year. The service package, because it's mandatory, it's required to live there, it does fall under the RTA as well. So those modest increases that have been over 16 years, the past 20 years, 16 of those years has been greater than the rate of inflation. That is the rate of increase that applies to the service package. So we believe that the RTB has not always followed the RTA rules, and that's been unfortunate. And that's why we're here today, to make sure that those seniors' rights, the tenancy agreements and tenancy rights that seniors are entitled to, like other renters, are enforced.
Okay, and by way of follow-up, so just to be clear then, so in instances where the service package is being increased by more than 3.5%, and you've talked about the example of 24% or 11% or whatever it may be in excess of 3.5%, every time that happens, that has been a violation of the law, you're saying? It's been an inaccurate application of what the tenancy rules are. And I guess if you're able to just confirm I understand that correctly. And the other question I had is, in those cases where someone said, okay, well, what if I want to sever the service part of the contract from the rent for just staying there, and then they've faced eviction? I guess you're also saying that should not be permitted either, to evict someone if they choose to not, pay for and receive the food services.
I think you painted the picture very well. The landlord is misinterpreting the RTA and exposing the seniors to higher rate increases than is allowable. The RTB, at the same time, is not interpreting the RTA correctly either. And when you think about the idea that if you're renting and you're forced to accept this service package, and then you see that the service package has been increased more than you can afford, and you go to an arbitrator and they rule not in your favor, well, you think about it. So we're saying that if you're saying that the service package is not included in the RTA, and then you evict somebody because they're not paying that, you can't evict somebody for not taking a service other than unless it falls under the Residential Tenancy Act. So we believe that it definitely falls under.
Next, we have Tessa Vander from CBC.
The places that you're talking about, are they all private, or do any of them receive public funding?
So for the independent living portion of the seniors living, all of these places are private pay. Some of them are privately owned. Most of them are privately owned. A few of them are nonprofits, and they may also be located on a campus with other services, but they're generally separate and privately owned and privately pay.
Did you have a follow-up?
Not right now.
Next, we'll go to Mary Brook with Island Social Trends.
So I'm just wondering about your discussions with landlords. What were some of the details of costs and complexities that they said would add to this problem?
Can you repeat the question? You were hard to hear.
Oh, sorry. Can you hear me better now? Better now. Thank you. Okay. I'm just wondering about your discussions with landlords and whether what costs and complexities were that they mentioned that would be an impediment to your recommendations coming into play.
Sorry, Mary, you're still a little difficult to hear. Are you able to try again, maybe a little louder and closer to the microphone?
Sure, yeah. I can try again. Can you hear me better now?
Mm-hmm.
Yes.
Okay, thank you. So I'm just wondering about your discussions with landlords and what were some of their objections or complexities that they mentioned.
Yeah, Mary,
go ahead.
Mary, thank you for the question. My conversations with the industry association and with operators, many of whom are my colleagues from 30 years in the field. Many of my colleagues I spoke to, the operators, in independent living, they are following the law. They are only increasing the allowable rent increase for both the rent and for the service package. When you hear about operators who are charging more, they're facing extenuating circumstances. That's why they are increasing those larger amounts. And they have the option of going to the Residential Tenancy branch and asking for an exemption so they can charge those prices. There is concern in the industry about the market and about the returns, if you will, and being able to pay for the investment of that. Those buildings are very expensive, and as are the property. That is what the industry is facing. And as I mentioned, the RTB has a process where they can ask for an allowable rent increase that's greater than what the posted amount is.
Did you have a follow-up, Mary?
Yes, thank you. The photos of work are quite surreal.
We're having difficulty hearing you again, Mary. Are you able to try again?
Yeah, I hear. I'm just looking at the photos in your.
You are muted. The host would like you to unmute your microphone. You can press *6 to unmute.
Right now.
Sorry, Mary, we're still having some difficulty. Perhaps we could
You are
coordinate a call
unmuted.
afterwards. Thanks, everyone, for coming. That concludes today's event.